Hi, I'm Tamara Monosoff, and I'm the founder of mominvented.com and my new mentoring and training website, tamaramonosoff.com. If you have a product idea that you're thinking about bringing to market, most likely one of the questions that you have is, how do I protect it? And that's why I am delighted to introduce you to my special guest and friend, John Merchant of J. Merchant Law. John is not only an intellectual property attorney, but also a business law attorney. John, thank you so much for joining us today.
It's great to be here. Thanks.
One of the questions that is just a buzz right now is that there is a new law that's affecting patents, and I know there's a lot of confusion out there in terms of what inventors should do about it and whether they should rush out and get a patent. So can you tell us about the law and how this impacts inventors?
Well, the United States law has changed to be more in keeping with the rest of the world. We're moving from what's called a first-to-invent system to a first-to-file system. And the way it used to be was that you would establish priority over who owned an invention based on when they invented it. So, for example, if someone invented something prior to another person, but filed after that other person, they could still prove that they own the invention because they invented it first. Now we've moved to a first-to-file system. So that means that if two inventors invent the same invention at the same or around about the same time, the first person to file the patent will own the patent rights for that invention. So that creates somewhat of a difference in the way people go about filing for patent protection. They often feel like they can't wait to file. They need to file in order to establish priorities, so they file as soon as they can. So that's the difference.
So what does this mean for inventors? I mean, that's a lot of pressure, it seems like, to rush out and patent your idea. What are your thoughts?
Well, generally speaking, you need to determine a couple of things, in my opinion, as to before you go out and file a patent. One, do I really have an invention that speaks to the value of the product in the marketplace? And if you're determining that, yes, I believe that what I have or some aspect of what I have is new, is novel and not obvious, and is patentable, then you need to reduce that to writing and get something on file as soon as possible to protect your patent rights. But you shouldn't jump the gun. You definitely need to determine, just what you have and provide the right amount of description for what you have before you can, obtain a patent right. So you have to think carefully, but it does create some pressure to file something sooner than before.
As a business owner myself, one of the things that I advise others is that they should wait until their product, they've done their market research to make sure that they've really incorporated all of the things that they want into their product before they rush out and get a patent. And so this is a little bit conflictual in the sense that, now the federal laws are saying to the first to file, and yet I don't know that it does inventors a real service if they put something out there that is then there, and then they change their product so dramatically that it doesn't match up with what they filed. What do you think about this?
Well, that's been one of the major criticisms of the new law, in that the argument is that it's going to hurt the smaller inventors, because they simply can't afford to go out and file patent applications on things that they're not sure they're going to bring to market. And so it does create some advantage for bigger companies that have big legal departments and a lot of money to spend on this kind of thing to go out and file. Now, there are certain techniques, certain things you can do to keep your costs low. If you feel like you have something that's patentable and you've got it to the point where you feel like you can describe it thoroughly, you can file what's called a provisional patent application, and provisional patent applications are less expensive to file. They simply create a placeholder. They're never read. They're not examined. No actual patent will issue on a provisional application, but it gives you a priority date. It gives you the opportunity to establish yourself as the first to file. So there are things that you can do.
Good. And I'm glad you brought that up because that is a topic for one of our future interviews. And so I hope that you'll go into much more detail about how to use a provisional patent application for inventors to their advantage. And so we'll go into that in more detail in the next interview. But I think that's it for now, John, and thank you so much for that explanation of the law. I think that's going to give inventors some clarity about the difference because I think it's been caused a lot of confusion out there, and so I really appreciate you taking the time today.
You're welcome. It's great to be here.
I hope you'll join us for our next segment with John Merchant of J. Merchant Law because John is going to next tell us about what the difference is between a utility patent and a design patent, what this means for you, which one is more powerful, and which one you can use to your own advantage as you're considering bringing your product to market. I hope you'll join us. Thanks so much.